This is Agriculture Today. We are back now with Roger McEowen. He is our K-State and Washburn University School of Law professor that joins us for our Ag Law Update. And this week we're going to be talking through property easement and sort of the tax issues around easement payments. So, Roger, let's kind of start with when we see cases of easement, what do we really need to think of going through that process?
It's a big issue for rural landowners. There are a lot of easements that companies are seeking across agricultural land, whether it's to move oil, whether it's to move other types of energy, such as a transmission line for electric energy, or whether it is a carbon pipeline where we're moving carbon from one area to store in another area. And these often go from one corner of the state to the other corner of the state and crosses a lot of farm owners' land. And so that raises questions because the landowner is going to get paid for these rights that they're giving up, such as the right to lay pipeline or construct a wind tower or the associated roads or electric lines, and to give access to be able to do these types of things. So the question is, I think the starting point is what's the character of these payments that farmers are receiving? So what's the character of the transaction?
Absolutely. And this is going to be part one of this conversation. We'll continue this conversation in a part two later this month. But characterizing the transaction, like you said, is key here. So what that means really, I guess, in this case is it a sale or an exchange? And what does that really matter in this situation? Well,
that's right. Like trigger recognition, they could be partially offset or completely offset by the recipient's income tax basis in the land that the easement impacts. Or a sale of the property could be involved. You could also have payments for crop damage that is involved in the transaction. But a sale or exchange triggers gain or loss for income tax purposes. And so the question is whether the grant of an easement is a taxable event. The answer to that is that it depends. When a landowner grants an easement, it amounts to a sale of the land if the only thing that the landowner has after they make the grant is just bare legal title to the land. If they have conveyed all the other interest in the property away, just retaining legal title, then that it amounts to a sale. And then the question is, in terms of reporting that, can I offset that income with any of my basis in the land that is actually impacted by the easement? And if so, I might be able to offset part or even all of that income as it comes in.
Absolutely. And there's several cases that you wrote through as examples of that sort of thing in an article recently that you wrote for your blog. And one of them was kind of the air rights over property.
Interesting case, the air rights case. We see this also with various types of government conservation programs and mitigation banking. And these are the conservation easements. And so if I'm granting, for example, a perpetual conservation easement in exchange for mitigation banking credits, which is one of the popular programs that's out there, then how do you treat that? Well, the IRS is going to come in and say that that's a sale or exchange. And in one instance, that's the position that the IRS held in a private letter ruling. And then the buyer of the mitigation credits, I think, is likely to be a dealer that won't hold those credits very long. And so they're likely to not have capital gain status on the sale. But the ultimate answer to the question of the buyer's tax status is going to be a fact-dependent determination. But you're right. We see this with air rights, and this is a very old case back in the 1950s. I guess it depends on what your context is in terms of very old. But what that was the grant of an easement for air rights over property that joined an air base that caused the property to be rendered useless, and that was deemed to be a sale. And then we get the grants of perpetual easements to construct a highway, for example. That's held to have been a sale. And talked about the perpetual conservation easement on property in exchange for mitigating credits. So this issue comes up in lots of contexts.
Absolutely. So that's our first step in understanding where we stand tax-wise with these easement payments, if it's a sale or exchange. But it's also important to understand if it's considered an ordinary income or capital gain. So let's talk through the differences there.
Yeah, if the payments from an easily rents for the land use, then that's going to be ordinary income in the recipient's hands. If it's a sale, then it's going to be capital gain. So that's going to be the dividing line right there. If I have conveyed all my interest in the property and the only thing that I retain, as I mentioned earlier, is just what we call bare naked legal title, then that's going to be a sale. That's going to generate capital gain. Then the question is going to be basis offset. If it basically is a lease of the property for a stated term, that's going to be ordinary income. We're going to report that as such on the return.
Key to know for sure. And then, of course, with easements, there's also different types of easements in terms of how the transactions actually take place. So with limited easements, when you grant that, what does that really include?
Well, it's in essence all of the rights in the land that are impacted by the easement. And then we would take the proceeds that are received and first apply them to reduce the basis in the land that's impacted. So in other words, if I have basis, income tax basis in the land that's impacted, then I'm going to offset that payment by that basis. And then I'll end up with a reduced basis in the land so that if I then later sell the land, I'm going to have more gain later on because I'll have less income tax basis at that point in time to offset the selling price. So if a grant of an easement deprives the taxpayer, again, this is the emphasis point, of practically all of the beneficial interest in the land except for just retention of legal title, then that's a sale of the land that the easement covers. So your gain or loss is going to be computed in the same manner that you would compute gain or loss on the sale of the land itself.
Absolutely. And then this is something that I didn't even think of, but the location of the easement really matters in these cases. So let's talk about what happens when an entire property is pretty much impacted by some of these easements.
Well, if the entirety is in, that's probably going to be the minority situation. And when we look at these easements, then that's a good thing from the landowner standpoint because that means that I've got a good argument that I can use my entire basis in my entire farm to offset the payments that I receive. But that's, again, I think a limited scenario when we look at all of these across the board. The location of the easement is often in a place where it doesn't disrupt your entire use of the farm. They're either going to run it down a fence line or they're going to run it across a corner of your property to try to minimize the impact on the overall farming operation. And in that instance, you only get a basis offset associated with the land that is directly impacted by the easement. Now, there are situations where, for example, if I'm running a dairy operation and this is an electric transmission line, that may throw off stray voltage that impacts my entire dairy. So even though the location may be designed to minimize impact, it also can depend on the type of the farming operation. So a dairy, that's got special considerations when it comes to electric transmission lines and the issue of stray voltage. But location is an issue. But I would emphasize that whether an easement impacts the entire parcel is a fact question. That is going to be different depending upon the facts and circumstances of each situation.
These severance damages that can be paid to compensate landowners, what does that really include in terms of the value?
Yeah, severance damages might be, and those are done to compensate the landowner for the lower value of the part of the property that's not subject to the easement. Because, again, it's you may have kind of this issue depending upon the type of easement, the type of line that's coming through, where, yeah, it directly impacts some property, but there's an indirect impact on the rest of the farm. And so a company may say, okay, yeah, we recognize we've lowered the value of the remainder part of your farm that's not directly impacted, so they make a payment for that. That's what a severance damage payment is. And if that exceeds the landowner's basis in the property, that is not subject to the easement, then gain is recognized in that situation. But
Sure.
Again, that's a fact question.
That example of, a dairy farm, a good example there in that case as well. And Roger, like I said, this is going to be part one of this series where we talk about different types of easements and the ways that they affect landowners and tax things and that sort of nature. But if listeners are looking for more information on this specifically, where can they find that at?
On my website, and that's washburnlaw.edu/Walter. And then down the homepage on the left side, they can access that. They're also posted to KSU's Ag Manager website.
We'll continue this conversation in our next segment in several weeks. But in part two of that series, we're going to break down the various types of payments that landowners can receive for easements and proper reporting of those payments. So listeners, stay tuned for that for sure. But as always, Roger, thank you so much for your time today.
Thank you, Samantha.
Once again, that was K-State and Washburn University School of Law professor Roger McEowen speaking towards issues associated with easement payments.